So I wanted to say something to you in this segment about the issue of costs, the costs involved to resolve disputes, the costs involved to manage and resolve disputes, and to give you a contradistinction between the way that we would work for you through early intervention, early management, early resolution, applying the system of contain the dispute, de-escalate the dispute, effectively manage the dispute, and resolve it early and preserve commercial relationships as against litigation as the alternative. And what I'm able to say to you is based empirically on my own experience to date, over 30 years. Just to begin with, I can give you some quick examples. A partnership dispute, for instance, that spills into the Supreme Court and maybe takes 12 to 18 months to resolve could very easily be at a cost of well over $100,000, maybe even $200,000. And the cost of that sort of dispute can be so prohibitive in itself that it makes the litigation very hard to pursue. Those very same disputes that can take that length of time to resolve and that type of cost, and which throws the whole partnership future and its financial viability into, it puts it at risk, if dealt with via early intervention and the methods that we use, those very, very same disputes, provided that the parties in the dispute come to the table together with a genuine commitment to try to resolve it early and without litigation, can be resolved within weeks or maximum maybe 2 months at a total cost all round relative to what I spoke to you about of maybe $5,000, $10,000, $15,000. So those are figures that I can give to you out of my own direct experience in working with these disputes. Another example, residential building disputes. A residential building dispute where a lot is involved, people maybe have entered into a contract for $600,000, $800,000, $1 million for their house to be built or for expensive renovations or whatever. They borrowed for that. In many cases, the owners are already at their financial limits. On the other hand, the builder may not be a big builder, may not be a large volume builder, so the cash flow is tight. They have to move on to various new jobs, otherwise their cash flow will dry up and they'll be in difficulty. So for both sides, the odds are high. Those disputes that happen to spill into a court or into the what's called the CTTT, Consumer Trader and Tenancy Tribunal, Home Building Division, can easily go for more than a year to be resolved, sometimes to a year and a half, and can easily cost each side $30,000, $40,000, $50,000 or more out of their own pocket to resolve that dispute. If we get brought in early to deal with those disputes, we can often resolve them harmoniously in the cooperative way with the parties within a matter of weeks and at a cost contained within about $10,000. That's the kind of difference we're talking about here. So in putting it in some sort of ratio, if you like, the cost difference could be that litigation may be 10, 20 times more expensive than the alternative, with a very uncertain outcome. If you were to decide in weighing this up that it's better to go for the early intervention, early management, early resolution, here's a very important thing to keep in mind. If you go that way, as opposed to litigation, you and the other party stay in control of your own dispute. We help you manage it and we help you resolve it, but you stay in the driving seat and you stay in control of it. You don't abdicate your dispute to a lawyer and to the court system that will then basically take over the whole thing for you, as long as you keep paying the bills, to take you down to some eventual hearing or trial with an uncertain outcome for you. So think about that. Which is the one you would, which is the preferred option for you. And I think in most people's cases, certainly from my experience in speaking to groups of people and speaking to many people personally, they almost always say they would, if it was available to them, they would prefer to go the alternative way and to be assisted, even if it meant compromise at some level. Even if it meant, for instance, the owner saying, well, I really feel I should get this, but quite frankly, if the builder does this and this now, that's enough for me to say this dispute's over and we can both move on. In the builder's case, the builder can often say, well, if I went to court, if I went to the tribunal, I might be vindicated on what I'm saying here is what I would be found to be right about. But I'd rather give way to the owners now and say, well, okay, I don't agree with you, but I will do this and this now, as long as I know you're going to pay me my next installment to get this dispute out of the way. Just think about that. On the cost level, on the level of avoiding future uncertainty and stress, which way would you prefer to go? This is really the message here. It's making sure that you are aware that there is an alternative way and that you can access it.